Are probate sales cash only? It's a question we get a lot, and there's a ton of misinformation out there on this. So I'm going to answer that question for you right now. Welcome back to the channel. I'm Brendan Moore, realtor and certified probate and trust specialist in California. Our team handles probate sales in California and Nevada, as well as non-attorney probate administration services in both states at a tremendous savings to our clients. So our probate sales cash only. There's a lot of misconceptions about this, but the straight answer is no. There's nothing in the probate code that says that probate sales have to be cash only. Now, one thing you need to understand about probate sales is maybe why you might see that a seller is only looking at cash offers, or perhaps they're going to put the most weight or most consideration into a cash offer. So the first thing to really know is that a lot of times probate properties are fixers. Now, that's not all of them, and you may very well have a home that you're going to sell in probate, and it's not a fixer. It's just that a lot of the times these homes have been sitting around for several months. Maybe the owner of the home who passed away did not have money to maintain the home. So in probate, it just tends to be more often that they're fixers. And the problem with a lot of financing options like FHA, VA, conventional financing, which are the most common types of loans that you get, there's strict, in some cases strict, and in other cases not as strict, but still certain property guidelines that must be checked off or present when lending on these properties in order for the lender to not make a risky loan. So let me talk a little bit about that. The most common types of loans are conventional FHA and VA. And I'll start with FHA and VA. But first, let's just start with the VA. VA is a veteran's loan. It's a federally insured loan, and they have very strict property condition guidelines, and it focuses on safety. And they're looking at things like, are there roof leaks? Is there a lot of visible wood rot? They can even be looking at things like tripping hazards or the burners on the stove work. There's a number of things. And if you were ever to look at the property condition guidelines for VA, you would see it's a pretty extensive list. So what happens is when a seller accepts an offer for anything with a loan product, then typically an appraisal is required. And with FHA and VA, it's most often always going to be, there's going to be an appraiser that's going to come out, and they're going to look at certain things. Now, an appraiser's job is to go out there and make sure that the purchase price is a legitimate purchase price, and they make sure that the condition of the home is what they call livable or safe. So they'll see if there's any visible wood rot. They'll also do certain checks. And they do this on every loan, where they check for smoke detectors, carbon monoxide detectors, and if you have a traditional tank water heater, make sure that it's double strapped. And that's going to be in FHA, VA, or conventional. So if those things aren't there, if those conditions don't exist, then the lender won't lend on it unless those items are corrected. Now, if there's a lot of visible wood rot or a leaking roof or tripping hazards, well, that could be problematic for VA, and those same property condition guidelines exist for FHA. The main difference between FHA and VA is there's something called a pest clearance or a termite clearance, and VA requires a clearance, what's called Section 1 of the termite report. And Section 1 is anything where there's active infestations of things like termites or wood-boring beetles, also things like wood rot. Now, in many cases, there can be a special form that just shows that if there are no active infestations of termites or wood-boring beetles or some sort of wood-destroying pest, then it'll pass for that particular guideline. Sometimes people think that it has to be fully clear of wood rot, and that's not necessarily the case. Now, if an appraiser sees a lot of wood rot on the home and calls it out as a condition to be corrected before closing escrow, then that's a different issue. There is the possibility of getting a special form that just says there are no active infestations of termites, and it just going on from there. Now, the home that you may be selling could have a lot of that wood rot going on, and what happens is if it needs to be corrected before close of escrow, then that's what needs to happen. Now, a seller doesn't have to do that unless they agreed to prior in the contract, but it's something you want to know going into it that is probably going to be problematic if you accept an offer with certain financing terms where a lender is most likely not going to lend on it unless these repairs are made. Most likely, a buyer is not going to do those repairs before they even own the home. So you can't expect that to happen. And it's not even good enough to give them a credit towards their closing costs in order to make these repairs because the condition needs to be corrected before close of escrow. Now, conventional is far more lenient, and you never really know for certain if an appraiser is going to call certain things out and ask them to be corrected. And that's really the case for even FHA and VA. But in the case of conventional, you might find that maybe they're only looking at if there's carbon monoxide detectors, smoke detectors, and a double strap water heater. Going back to the property condition guidelines, if you look at the guidelines, you'll see it's a long list. And sometimes the appraiser comes out there and doesn't look at half of those things. I've had times where an FHA appraiser comes out and sees some things that really very minor things that they've called out, like a tripping hazard that is maybe some pavement that is raised by an inch. And then another FHA appraiser comes out to a different property and finds raised pavement that is, something like 6, 7, 8 inches over the entire length of a driveway and not call that out. That's a true story. I've seen that in back-to-back FHA appraisals. So those are some reasons why you would maybe see that a probate property would be cash only. And it's just because there'd be financing complications if they did not accept a cash offer. Now, it's always ultimately up to the seller if it's going to be cash only. It's usually by advisement by the realtor, or in probate, sometimes even by advisement by the attorney or probate professional who's ever actually handling the probate. But sometimes you'll go and look at the house and you'll see that, hey, this really isn't all that problematic. Your agent may talk to, if you're a buyer, your agent may talk to the listing agent and say, hey, I don't really think this is bad. Want to give this a shot. And my client is, maybe conventional, and see if we go from there. So that is a possibility. It just depends on how much risk the seller wants to take, or of course the agent on behalf of the seller. Now, another thing that can affect whether or not the seller is considering offers that are not just cash offers, but financed offers, is the type of authority that the court has granted the estate. Now, if you've watched my video, full authority versus limited authority, it's going to give you a lot of information about the two types of authority. Full authority is, at least from a buyer's perspective, very similar to a normal real estate sale. So in that case, I don't think that type of authority should be a determining factor in whether or not you're going to accept financed offers. Now, limited authority, because it takes so long, it's a several month long process, and you can't have contingencies once you get to that court date, and then it may not close for several days to weeks after that. There's costs for publications, for public notices that could get into the several hundreds, maybe even over $1,000. That's where you want to make sure that whoever is buying that property, that when they have a loan, that it's not going to be problematic when it gets down to the time for closing, and especially things like when the appraisal report comes in. You don't want to be several weeks into this. Maybe you spent money on the publication already, and you have that court date set for the court confirmation hearing, and find out that the appraiser is requiring repairs in order to close escrow, or it could be maybe even the appraisal came in low, and you have to lower the price. Now, in a case of limited authority, you have to redo all the publications, refile for the court confirmation hearing a lot of the times, because you don't have enough time to file those new publications and give proper public notice. So now you've just wasted a bunch of time, a bunch of money, and you have to probably lower the price, or maybe even just find a new buyer. A seller, remember that a seller doesn't have to make any repairs that they have not contractually committed to. So a lot of times what happens is, if an appraisal report comes in low, or they're requiring certain repairs, the seller will often say, sorry, we can't do it. And then both sides are canceling the sale. So that is often a reason why you will see a cash only sale for limited authority. Another thing about that court date is you don't get to keep the same court date if the escrow falls out. So say you accepted an offer from Bill Smith, and then maybe you file for the court hearing, and it's 2 months out. Okay, so sometime within the next 3 weeks, you find out that the lender is going to require certain repairs before closing of escrow, and you're not going to do it. Well, when that escrow is canceled, so is that court date. You don't get to keep the same court date. You have to put the home back on the market, get a new offer, send the new contract to the court to request the hearing, do all the publications over a series of weeks. That's their public notifications that there'll be a court hearing, and the whole overbid process is what that's all about, and go from there. So that's another reason why it's problematic to for it to be something that is not a cash sale when you're dealing with limited authority. So those would really be the reasons why. But if you ever run across one, if you're a buyer and you're running across a probate sale where they say cash only, you may want to have your agent look into a little bit further and see if there's something that can be worked out. But if it's one that's full authority and the condition looks good, there shouldn't be a reason why it wouldn't be something where they can accept a regular financed offer. Now, one thing when it comes to a big reason why you want the home to be in condition to accept a financed offer is you just limit the pool of buyers when you're dealing with cash only. And a lot of cash only buyers think that they can get homes below market value. So you're most likely going to get a better sales price, better overall terms, better overall net for the estate when you can open up the buying process to more buyers with more types of lending options. So I hope that was helpful for you. If you have any questions for me, please remember to comment below, like this video, subscribe to our channel. We have so much information for you. And if you want to know more about this process, watch our video regarding the probate real estate timeline. It's linked next.